Happy Saturday! Now send me a list of 5 things you did this week or you're fired. No, I'm not going to read all 4 million emails, but I'm so obsessed with efficiency that I'm going to cause millions of government employees to waste their entire workday trying to figure out 1, if you need to respond, and 2, what you can possibly say while not violating government secrecy laws or other ethical obligations. Yes, I'm a genius. On Saturday, February 22nd, the Office of Personnel Management, or OPM, sent an email to federal employees instructing them to respond with 5 things they accomplished last week, or else they would lose their jobs. When Musk bought Twitter for $44 billion, he sent a similar email to Twitter employees, demanding that they send him screenshots of their most salient lines of code. Musk then fired thousands of them, leading to dozens of lawsuits, all of which he's lost so far, and a diminished user experience at Twitter, to put it lightly. And now that Elon Musk has purchased the US government for a much lower price, he got to work making America more miserable for everyone, but especially government employees. Now, Musk's ostensible mandate is to make things more productive and efficient, and what better way to do that than by giving employees busy work and new bureaucratic puzzles to solve? It's not like they've got anything better to do, like, I don't know, making sure planes don't collide in midair, monitoring the transmission of avian flu to humans, and preventing people from dying while climbing the Grand Canyon. That stuff can wait. Now name 5 things you did last week, losers. Now we still don't know all the repercussions of the email blast, but as you'll see, there's a very interesting legal twist. And it seems that the government's representations in court are finally coming back to bite them. And in fact, one lawsuit that was filed long before the email blast went out might be the reason that people don't get fired for ignoring it. And in another twist, the person who filed that lawsuit is someone that you've probably seen on this channel before. But let's take a step back. When Doge employees took over the Office of Personnel Management in January, they set up a new email system that let the OPM email all federal employees through a single distribution list. The new system was called the Government-Wide Email System, or I'm assuming it's called the GWIZ. It sends emails to federal employees through the email address hr@opm.gov. Now, I'm new to American politics, so I assume that everyone on both sides of the aisle is totally cool with an unauthorized email server. But storing private and classified information on an unsecured server is a big security risk. And we don't know where the OPM server is physically located or who built the system, but it seems the system is now retaining information about every employee of the US executive branch. And it seems to be going far beyond federal employees. It appears to be retaining information about every person with a .gov or .mil email, which is a much bigger set. And there's also evidence that employees of the judicial branch, including lifetime appointed federal judges, are also getting the emails. Now, civil servants are worried that their personal information is not secure. They say, quote, standard email is not encrypted, and it is common practice among hackers, including hackers affiliated with hostile foreign services, to begin attempting to access a new US government device as soon as they learn of its deployment. Now, sure, that sounded like a big problem, but Elon Musk wasted no time in using the system to send an ultimatum to federal workers. On January 28th, OPM sent an email with the subject line "Fork in the Road" to roughly 2.3 million government employees. And as we talked about at the time, the email rolled out a deferred resignation program that really wasn't a resignation program, where people could stay on until September 30th working remotely with pay and benefits, but they still had to do their own jobs. And the email instructed employees to respond by February 6th. Now, it was easy to see Elon Musk's hand in this because he did the exact same thing when he purchased Twitter. Musk sent an email with the subject line "Fork in the Road" and gave Twitter employees 24 hours to decide if they wanted to work for him or quit. And Musk eventually fired about half of Twitter's workforce. But as Elon Musk soon found out, sending an email to everyone connected to the government is not the same as sending a company-wide email. Federal employees have civil service protections, and they filed several lawsuits challenging the legality of the deferred buyout program. And for more information about the Fork in the Road debacle, you can check out the video that we did with Liz Dye. But undeterred by lawsuits, on February 22nd, Elon Musk tweeted that, quote, consistent with President @real Donald Trump's instructions, all federal employees will shortly receive an email requesting to understand what they got done last week. Now, if it took you a second to parse whatever requesting to understand means, don't worry, it took me a second as well. I think what he meant to say is they'll get an email asking what people did last week. Now, 2 hours later, the OPM sent employees an email instructing them to respond with 5 things that they accomplished last week. Quote, please respond to this email with approximately 5 bullets of what you accomplished last week and CC your manager. Please don't send any classified information, links, or attachments. Deadline is this Monday at 11:59 p.m. Eastern Standard Time. Now, this was yet another email modeled on Musk's Twitter takeover. When Musk purchased Twitter, he told the employees to, quote, email him a bullet point summary of what your code commits have achieved in the past approximately 6 months, along with up to 10 screenshots of the most salient lines of code. That email was a prelude to mass terminations. And federal employees were understandably confused. The email was from the random HR address rather than their supervisors. The email itself did not say what would happen if employees missed the 11:59 p.m. deadline. And in a contradictory fashion, Musk's tweet warned them that failure to respond will be taken as a resignation. So did they have to respond or not? What happens if all of your work is classified? How are you supposed to summarize that? Well, apparently when you move fast and break things, nobody knows what's going on. For example, quote, officials at the Departments of Defense, State, Homeland Security, and Energy told workers not to respond. But leadership at the Cybersecurity and Infrastructure Security Agency and the Federal Emergency Management Agency, which are both housed within DHS, told their employees to answer the email. Treasury, Veterans Affairs, Commerce, and Interior instructed their employees to respond, but warned them not to share any classified information. The Department of Health and Human Services, which is now run by a guy with a legal brainworm, had no idea what was going on. At first, supervisors told staff to reply, but just hours later, the agency backtracked. On the following Sunday night, HHS sent an email asking employees to pause responses pending additional guidance. And the HHS acting general counsel said, quote, I'll be candid with you, having put in over 70 hours of work last week advancing administration's priorities, I was personally insulted to receive the below email. And according to the AP, he was concerned that some agency employees could not discuss their work because of attorney-client privilege. One day later, HHS sent a third email, quote, there is no HHS expectation that HHS employees respond to OPM, and there is no impact to your employment with the agency if you choose not to respond. And HHS said that if anyone wanted to respond, they should not identify other HHS employees they worked with, matters they are working on, or specific grants or contracts. Quote, assume that what you write will be read by malign foreign actors and tailor your response accordingly. And I assume by malign foreign actors, they mean President Donald Trump. Speaking of whom, President Trump, ever a beacon of clarity, insisted that federal workers were required to answer Elon's 5 things email.
What he's doing is saying, are you actually working? And then if you don't answer, like you're sort of semi-fired or you're fired, because a lot of people are not answering because they don't even exist.
But while Trump was defending Elon's email, the OPM was contradicting him. OPM told federal employees that, quote, any employee response to the email is voluntary and that not responding will not be considered a resignation. Meanwhile, OPM's acting director, Charles Ezell, was silent about whether employees who didn't respond had resigned. Ezell said, quote, agencies should review responses and evaluate non-responses, and that agency leaders, quote, may exclude personnel from this expectation at their discretion. Ezell put the pressure on supervisors to decide whether to fire people. Quote, agencies should consider any appropriate actions regarding employees who fail to respond to activity accomplishment requests. It is agency leadership's decision as to what actions are taken. But the Monday deadline came and went, and Musk fumed about it on Twitter. Quote, subject to the discretion of the president, they will be given another chance. Failure to respond a second time will result in termination. So instead of clarity, we got a whole bunch of chaos. However, a lawyer emerged to save the day. Now, if you're mishandling troves of government data and lying to the courts about it, you'll probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, whether Elon Musk was at fault or not, especially if you got one of those data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue, maybe because you got fired by the government, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can maximize your recovery. And we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Now, back on February 5th, Kel McClanahan with the National Security Counselors filed a lawsuit accusing the OPM of setting up an unauthorized, insecure server to send mass emails without conducting a privacy impact statement as required by law. And additionally, you might have also heard of the illegal email server. Well, our friend and fellow attorney Kel McClanahan filed a lawsuit against OPM on behalf of government employees who received potentially illegal and unsecured emails from Elon Musk and his Doge team. The 7 plaintiffs are either employees or affiliates of various government agencies or organizations. They allege that OPM, working with Doge, set up an unauthorized server built by a commercial entity to conduct email blasts without providing a privacy impact assessment for it. The lawsuit asserts that OPM used the server to send several test emails to workers across the government, as well as the fork in the road emails, which offered deferred resignations to federal employees. Now, under the E-Government Act of 2002, federal agencies are required to complete a Privacy Impact Assessment, or PIA, before initiating any new collection of personally identifiable information, PII, using information technology. This assessment must evaluate what information is collected, why it is collected, how it is to be used, with whom it is to be shared, and how it will be secured. Additionally, agencies must ensure that the Chief Information Officer or an equivalent official reviews and signs off on it. The appropriate government official must make the PIA publicly available through their website. the Federal Register, or other means. But here, the OPM allegedly did not conduct a PIA for the new email system and the server in question. McClanahan apparently discovered the issue when an OPM employee posted information to a union chat and someone circulated the message on Reddit. And the Reddit message warns of dire circumstances within OPM. Quote, an on-prem, on-site email server was set up. Someone literally walked into our building and plugged in an email server to our network to make it appear that emails were coming from OPM. It's been the one sending those various test messages you've all seen. We think they're building a massive email list of all federal employees to generate mass RIF, reduction in force notices, down the road. The non-political civil servants here at OPM are watching helplessly as our government is being systematically dismantled bit by bit. Even the IGs are being fired to prevent them from investigating the numerous whistleblower complaints we filed. The message also discusses the resignation of OPM CIO Melvin Brown. The message said Brown, quote, was pushed aside just 1 week into his tenure because he refused to set up email lists to send out direct communications to all career civil servants. And the plaintiffs are concerned about the security of their PII being stored on an unknown server. They cited the infamous 2015 data hacks, which compromised the information of 21.5 million people, including sensitive data drawn from background checks. Quote, standard email is not encrypted, and it is common practice among hackers, including hackers affiliated with hostile foreign services, to begin attempting to access a new US government device as soon as they learn of its deployment. Plaintiffs moved for a temporary injunction, declaring that the OPM's actions violate federal law, compelling the OPM to publish a legally sufficient PIA, and ordering the OPM to disgorge all improperly collected information. In response, the Trump administration opposed the TRO. They argued that the plaintiffs misunderstood the E-Government Act, and the government says that the act requires privacy impact assessments only for systems that deal with public information, whereas the OPM system only handles information related to federal employees. However, plaintiffs say that non-executive branch employees received some of the emails. For example, FedScoop reported that, quote, employees at the Library of Congress, which is a legislative branch agency, and thus outside the direct scope of the Trump administration's workforce actions, received a test email. The Trump administration denied that it was required to file a PIA, but filed one a mere hour before Kell's lawsuit went in front of a judge. So we thought we'd ask Kell McClanahan directly. So, Kell, what happened?
So what happened was that we were overtaken by events, as often is the case when dealing with these Trump actions, where we had filed a case when all we knew about the server was that it was sending out test emails. It was before they even sent out that fork in the road email. And then we filed a TRO a week later based on everything new we had learned about the system and said you need to shut it down until they do a PIA. Then, as you say, the day of their opposition to the TRO, they said, here's a shiny PIA that we just did. It's moot now, right? The judge said, well, you didn't say in your TRO motion or even in your complaint that they had to file a proper PIA. You just said they have to file a PIA. So I'm going to hold that this motion that you have filed is moot because they filed a PIA. However, if you want to argue that they filed a POS PIA, then you need to amend your complaint and file a new TRO. Do that tomorrow. And so we did that last night.
Now, the government alleges that the PIA requirement doesn't apply here. What do you say to that?
This is, first of all, just factually irrelevant and inaccurate. They did not collect information from just federal government employees. And that doesn't matter for whether or not you define federal government to be just the executive branch or the government as a whole. They collected it from everyone with a .gov or .mil address, which is more than just federal government employees. So it's just wrong. It doesn't apply. Number two is that prior to last year, the OMB guidance would have been entitled to, let's call it deference, perhaps even Chevron deference. And a whole bunch of people went and sued on behalf of Republicans everywhere to get rid of Chevron deference and say that judges can make decisions about whether or not they believe a law requires something, regardless of what the agency guidance on that says. And now they're turning around and saying, well, this agency guidance says that this does not apply. Therefore, ta-da, I found one weird trick. And that's nice. You're not entitled to Chevron deference anymore because you caught the car and you won that argument in Loper Bright. And it's up to the judge to decide if this applies to collections of information about people besides federal government employees. But then again, he might not because, as I said before, it's not just limited to federal government employees. And so this just falls flat.
What about the emails to the Library of Congress? Could they be construed as members of the public?
Well, they can, and they can also potentially be construed as federal government employees, depending on how you want to parse federal government. But even then, it doesn't matter, because we know that legislative branch employees got this email. Judge Moss said in the hearing on Thursday that he got the email. And we've had wide reporting that judicial branch employees got the email. And I have clients who are contractors who got the email. And so even if you say that federal government employees applies to everyone in every branch of government, it does not apply to the contractors. It does not apply to the state of California employee, who is one of my clients, who got the email because she was in a program that partnered with a government agency. And so that's why she had a .gov email address. It just is an irrelevant point. These are a lot of arguments that are nitpicking based on the assertion that it only collected information about executive branch employees or maybe larger government employees. But once you knock that down, the whole house of cards falls.
Am I curious? Yes.
And what do we know about the OPM's PIA issued on February 5th?
All we know for sure is that it was done sometime between January 22nd, which was the day that Greg Hogan, the signatory, took over as chief information officer, because we know that Melvin Brown, his predecessor, refused to allow the government-wide email system to happen. It was also done sometime before February 5th, or including February 5th, because that's the day they filed it in my case, where they dropped it at 10 o'clock in the morning when we were supposed to have a status conference at 11 o'clock in the morning. So, that's not suspicious at all. It is more likely that it was done after I filed my temporary restraining order motion, but we don't have evidence of that. But what we do know is that even if they started writing it when they started doing the system, that's still only 2 weeks. You don't do a PIA for a major information system in 2 weeks. You do a PIA in, at best, 2 months, because it's complicated. Okay, fun fact. The reason that the OPM hack happened in 2014 was because the Chinese were very, very methodical and very, very patient. And they found an access point where they were able to spoof coming from opmsecurity.org, which fooled the system into thinking they were part of OPM. Then they sat there until they saw an opening, and then they stuck a person in there who could log in and be recognized by the system as an authorized individual. The system thought that that person was need to know as far as the access goes. So the fact that they are saying this system can only be accessed by people with the need to know is predicated on the idea that the only way to access the computer is by walking up to it and sitting down in front of it and typing into it. However, that is not how things work in cybersecurity, and even the net got that right. And so as long as they are sitting out here with this server with all of this information on it, the server doesn't know if you're sitting down in front of it or you're accessing it remotely. I guarantee you that some of these guys are accessing it remotely. And so what are we supposed to draw from this? What are we supposed to conclude by the fact that our security measures are, we make sure people can't get into the room where it's sitting connected to the entire network?
What do we know about exactly when this PIA was done?
PIAs take a long time to work on because they are important. And in fact, the law requires that the complexity of a system be commensurate with the complexity of the PIA. And when you have something like a major information system, as the law defines it, you have to be even more specific. So when you have that, and you look at the other PIAs that even just OPM has promulgated for its other systems, one of which is actually the Microsoft Office 365 information system that they use for all their communicating, you see these are very specific requirements. And these are very specific answers. They say who is doing what, why we decided on doing this, what security measures were considered, what we thought after we did the PIA, how we adjusted the way we used the system, et cetera, et cetera. Then you have this PIA. And this PIA, I want to make clear, I call a PIA so that every answer doesn't have to go with this document that purports to be a PIA. This is not a PIA. This is, as someone said a couple of days ago, a restaurant menu with PIA written across the top of it. It says things like, we don't need to do this because we are being very secure. How is the data being protected? It's being protected by protective measures. It does not give answers to any of the questions. Some of the stuff it says is factually just wrong, like we only collect information about government employees. Some of the information is extraordinarily misleading, and even if you accept that everything in it is truthful, it's still woefully legally insufficient.
Thanks for coming on, Kel, as always. And if you'd like to support the work that the National Security Counselors is doing, we'll leave a link for that down in the description. They receive a lot of their funding through private donation, and their work is more necessary now than it ever has been. Now, it seems that in response to the suit, OPM tried to conduct a privacy impact statement for the GWiz email system. The privacy impact assessment stressed that participation in the system was actually voluntary. Section 4.2 says, quote, "The employee response data is explicitly voluntary. The individual federal government employees can opt out simply by not responding to the email." And OPM acknowledges that some employees might not realize they aren't required to respond to these government emails. So the PIA concludes this risk can be mitigated, quote, "by ensuring that any email sent using GWiz is clear by explicitly stating that the response is voluntary and by including specific instructions for response." Which is super weird because none of that language was ever included in any of these emails. But the OPM argued that the PIA mooted the case, quote, "Because the agency has in fact published a PIA despite it not being required to do so, this case is moot and plaintiffs cannot establish irreparable harm." Problem solved? Well, that response convinced the judge to deny plaintiffs' motion for a temporary restraining order, but forcing the OPM to publish a PIA wound up accomplishing quite a bit actually, because the OPM told the court that employees did not have to respond to these mass emails. OPM claimed that the government workers who had received emails from the email system had limited privacy protections, but OPM sent emails to people who were not within its jurisdiction, the executive branch. The 5 Things email even went out to some federal judges who obviously work for the judiciary and can't be fired by OPM. And according to an email from the director of the Department of Administrative Services for U.S. federal courts, quote, "We understand that some judges and judiciary staff have received an email from hr@opm.gov. Please be advised that this email did not originate from the judiciary or the administrative office, and we suggest that no action be taken." So if any of these employees responded, they might now have standing to sue along with their executive branch counterparts. And since the emails went out to so many people who were not executive employees, plaintiffs filed an amended complaint expanding the proposed class to everyone with a government email address. And Kel has now moved for Rule 11 sanctions against the government. Under Rule 11c2, lawyers must give the opposing side 21 days to correct the offending conduct. And he asked the court to shorten the safe harbor period to just 5 days, and the judge agreed, so the motion is now on the public docket. And plaintiffs allege that OPM submitted false evidence to the court in an attempt to avoid a temporary restraining order. And the PIA asserts that the GWiz system only collected voluntary responses from federal employees, and the PIA reiterated this claim 5 times. However, as we just discussed, the system was actually used to gather responses from non-executive branch employees, including judiciary staff. Guidance from the president and some agencies indicated that responding was mandatory, and the court relied on this inaccurate information when denying the initial TRO. So according to the plaintiffs, quote, "Both of these actions demonstrate a clear lack of candor to the tribunal, and OPM and its counsel should be sanctioned for unreasonably multiplying the proceedings and violating the integrity of the court's process by entering statements into evidence which were known to be false and then citing them uncritically to the court to convince the court that OPM's actions were legal and that plaintiffs were not at risk of imminent harm." Now, in the wake of President Trump's executive orders, there have been a deluge of federal lawsuits that have been filed. I think over 100 at this point. But I believe that this is the first time any of the plaintiffs' lawyers have sought sanctions against the government. But given the representations that the government is making in court, I doubt this will be the last motion for sanctions. And here the motion cites 3 legal authorities for imposing sanctions. Rule 11 requires attorneys to ensure that filings are factually and legally supported and not presented for improper purposes such as harassment or delay. Plaintiffs argue that, quote, "OPM and its counsel intentionally, unreasonably, vexatiously, and in bad faith entered a document containing false information into evidence and argued that the court should rely on the statements made in that document." Plaintiffs twice asked the court to grant a temporary restraining order, and both times OPM lawyers asserted the issue was moot because of the PIA. So this undoubtedly added expense and time to the litigation. And as plaintiffs point out, quote, OPM convinced this court to deny plaintiffs' first request for a TRO, force the parties to brief a second motion for a TRO, and are forcing plaintiffs to respond to a motion to dismiss, which is largely predicated on the fact that the invalid and inaccurate GWiz PIA is in the record. Plaintiffs argue that because OPM and its counsel knowingly submitted false evidence, misleading the court and prolonging the proceedings, the court should strike the PIA from the record, prohibit OPM from relying on the PIA at this stage in the litigation, order OPM's lawyers to file sworn statements regarding how much they actually know about OPM's representations, and grant the plaintiffs any other relief that would deter OPM from repeating the conduct. Now, the court hasn't ruled on this motion yet, but on Friday night, OPM updated the PIA, sent out another round of emails, and issued more conflicting guidance. It really does feel like Groundhog Day because the Department of Government Efficiency is making everyone do the same thing over and over and over again. But the updated PIA says that responding to the email system is voluntary, but quote, the consequences for failure to provide the requested information will vary depending on the particular email at issue. OPM and the agencies then sent a second version of the 5 Things email. The subject line was, "What did you do last week, part 2? The email directed employees to file a weekly response summarizing what they accomplished. Now, some employees received this email from their agencies, which could be a different strategy to moot the case, because there's probably nothing wrong with asking an employee to respond by email to their direct supervisor. However, some employees still received the email directly from OPM, and OPM made the situation more confusing by telling agency leaders they should send a copy of their response to OPM, and OPM didn't say what the agency planned to do with these emails. OPM did say, quote, agencies should review responses and evaluate non-responses. And once again, agencies are taking different approaches. This time around, the State Department told its employees they did not have to respond to the email, but the Defense Department said all civilians must respond to emails from Pete Hegseth within 48 hours, and over at DHS, employees were directed to send their responses to an email address at DHS. And once again, Elon Musk issued directives from his Twitter account, quote, the president has made it clear that this is mandatory for the executive branch. Anyone working on classified or other sensitive matters is still required to respond if they receive the email, but can simply reply that their work is sensitive. So responding is mandatory or discretionary, and the consequences are dire or non-existent. But with respect to the OPM lawsuit, the plaintiffs took a loss when the government denied the motion for a TRO, but they at least forced OPM to cough up a document that lawyers all over the country will now use against them. And while we don't have a permanent resolution in this particular case yet, the lesson here is that it's good to make the government go on record about what it's doing. And as for what OPM will do with the 5 Things email, the humor website McSweeney's predicted that the government will, quote, feed them to an AI which will flag any forbidden words like diversity and woman, so it can eventually be read by a racist Doge bro. And what do you know, NBC News has just reported that Doge will use AI to review all the responses. Now, OPM's blatant disregard for privacy and the need to protect people's personal data is just the tip of the iceberg. Leaks and data hacks are happening all the time, and when your private data gets compromised, it gets sold and resold all around the world by data brokers. Luckily, there are people out there who can help, and that's why we recommend signing up for today's sponsor, Incogni. You can use my link in the description of the code LegalEagle for an exclusive 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If the data brokers resist, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. I've been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning that the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you to Incogni for saving me hundreds of hours and adding me to over 40 suppression lists. And the best part is Incogni will continue to conduct ongoing removals, because even if the broker removes your data once, they can collect it again. Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you keep it, you still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word. So after that, click on this link over here for more LegalEagle, or I'll see you in court.